Welcome back. Well, the finer details of Oscar Pistorius' court-ordered psychiatric tests will only be known next Tuesday. That's when the official order will be handed down. Judge Thokozile Masipa yesterday ruled the athlete must be evaluated to establish whether his alleged anxiety disorder played a role on the morning he shot and killed Reeva Steenkamp. Well, to give us some analysis on this now, I'm joined by criminal law expert Ulrich Roux, who is a director and defense lawyer at BDK Attorneys. Ulrich, thank you very much for joining us. And just so we can get rid of those questions, you are not related to Barry Roux, so we'll clear that up. We have cleared that up.
No,
so
just friends.
Just friends. All right. Well, this move, or the decision by Judge Masipa, being described by some media as well as a blow to defense. Is it a blow to the defense?
Not at all. At this stage, the interests of justice must prevail in this matter. And our Act states quite clearly in terms of Section 78 that if there's an allegation made and there's merits in the allegation that a person at the time that the offence was committed was not of full and sound and sober senses, in other words, he lacked criminal liability, then that person cannot be convicted of that crime. So when the allegation is made, it is in everyone's interest for that person to rather be assessed to ensure that he receives a fair trial and to ensure that the trial can continue. Alternatively, that he be admitted for treatment.
Now, a lot of comment out there, a lot of suspicion as to, is this sort of a desperate time for the defense to actually do this now? Why was it not actually done earlier? This is over a year since this crime was committed, and over a month since this trial has actually began.
Not at all. I think that was not the intention when Dr. Merrill Foster was called for this to be the outcome. Not at all. I think they called her in order to create the perception, or not create the perception, but to testify towards what Oscar has said all the time. He's been a victim of crime. He's been very wary and cautious of violence and crime surrounding him, and that's how he's lived his life, and that is what she testified to. During her testimony, it came out that he in her opinion, he does suffer from GAD, generalized anxiety disorder, and that is when Harry now saw the opportunity. Remember, the reason why he made such a big deal about it is because at a later stage, in other words, say for instance there is a conviction and during mitigation of sentence, this evidence comes to light that could pose a problem for the state when they argue for a sentence to be handed down, as well as if the matter would go to appeal. It could pose a problem because when an allegation is made and in the appeal process it's on paper, the judges will look at it and say, well, here's this allegation. Why was this person not sent for an assessment if the allegation is made? We have Section 78 of the Act, which dictates what must happen, and no one did it. So I think that is why, and everyone's entitled to a fair trial, and Harry Nall, I think, did very well in bringing the application.
Does this sort of lessen the chance of an appeal by the defense later on then?
Well, it might on these grounds, on this specific ground, but not in general, no. There's always, when there's an opportunity for an appeal, one must evaluate the entire trial and one must identify grounds for appeal. So certainly this would then not be a ground because he will be sent for assessment, but there will be other grounds, probably, yes.
What are the possible outcomes here now after Oscar is sent for the psychiatric evaluation?
Well, what happens now is on Tuesday, Judge Masipa will hand down a detailed judgment. Now, what that means is the defense and the state need to talk to each other and determine what will be the best outcome and how to deal with this assessment. There are various factors to consider: where he will be assessed, which institution, for how long, and whether he will be an inpatient and an outpatient. Now, the important thing about that is when a person is an inpatient, you tend to wait for a bed to become available. Now, that means that person stays over at the facility and he gets monitored 24/7. Now, unfortunately, in our system, there aren't any beds available. I've had clients who've waited for 9 months for a bed to become available. So if the parties can agree on him being treated as an outpatient, that could speed up the entire assessment process. So when that order is handed down on Tuesday, he will then be assessed. Then a panel will assess him, which comprises of 3 psychiatrists and numerous other psychiatric staff, and they will then furnish the court with a report. And the court will then be led and guided by this report
as to whether he's fit to continue.
Yes, whether he's fit to continue with the trial or whether he should be sent for further assessment, whether he should be admitted, whatever the case.
So what happens if he's found to be unfit to stand trial? Does this case get scrapped, or does he spend the rest of his life at a facility?
In terms of Section 78, there are 4 different orders which the judge can hand down. The one is in terms of Section 47 of our Mental Health Act, and that states that he is then admitted as a patient of the state. So he becomes a state patient, and then he, upon his curator, in other words, the person who's looking out for his interests and acting on his behalf, bringing an application to a judge at any period after any period of time, and the judge then finds him to be a fit and proper person, he will then be released, but he will be treated. The second one is in terms of Section 37 of the Mental Health Act. He will be admitted, also taken up in a psychiatric institution, and then evaluated 6 months after being admitted, and then every 12 months thereafter. And if he shows progress, and it shows that he has recovered from whatever disorder he suffers from, then he will be released.
In that time?
Yes.
Okay.
She can also find him not guilty. In other words, he lacked criminal liability at the time that the offence was committed, and then she can release him, find him not guilty, and the matter will be done, but she can release him with conditions. And then the fourth one is that she finds him not guilty and does not impose any conditions upon him.
Okay.
So theoretically, if Oscar, if he is assessed and they find him to be lacking complete criminal liability, and remember, it's not now, it's at the time that the offence was committed, then he could theoretically be discharged, and the charges can be withdrawn against him. He can be a free man.
We'll just have to wait and see. Thank you very much for your time, Ulrich Roux, who is a director and defense lawyer at BDK Attorneys.
You deserve to know more.
eNCA.com.